Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are going to discuss a case law on section 311 CRPC. So 311 CRPC normally we have used it umpteen number of times. What happens is 311 is re-examination of the witness. Suppose as a police officer on certain date I have to attend the court, but on the particular day due to some other work I may not be able to attend the court. But if the judge is actually not acceptable, definitely he will close the prosecution, he will close my evidence and he will continue, he will take the next step. Then what to do? Reopen, that is 311 CRPC, re-examination, reopening the case, that's better word. So then I can approach the PP and file a memo under section 311 CRPC. Normally the court will agree and examine me. So re-examination of witness in necessary circumstances. Here the court held that, Supreme Court case, held that the witness cannot be recalled under 311 CRPC merely because he gave a different version in another case, where the person is the same accused, witness is the same, accused is also one of the same persons. So if he gives statement in one case and he gives a different version in another case, definitely, normally we will be under the impression that he can be called, but Supreme Court said, no, you cannot call him because it is not a contradiction. Why not contradiction? Will? So this is the case law decided by Honorable Judges C.T. Ravikumar and Sudhanshu Dhulia of the Honorable Supreme Court in the case of Said Faisal versus State of Uttar Pradesh and another in SLP number 5647 by 2022, decided on 21st June 2022. Right. So this is, in this particular case, let us go to the brief facts better. On 11/8/2014, please remember, on 11/8/2014, so the witness PW1, Mr. Naushad, right, he gave a statement during the chief examination against Said Faisal. What did he say? PW1, as PW1, he stated that he identified the accused Said Faisal as one of the accused persons carrying a rifle and attacking the deceased person. And it is a case of 302. In murder case, he has given evidence, right? Even he was subjected to lengthy cross-examination, but there was no contradiction. He said that he identified Said Faisal. Right, that's one part. This happened on 11/8/2014. The UP government actually registered a case against the same Said Faisal under Gangsters Act, just like our that is 401, that is gang dacoit, gang belonging to gang dacoit case. Alage second is prevention of unlawful activities of bootleggers, dacoits, like that, rowdies, like that. They have got the so-called Gangsters Act. So in this connection also, this man Naushad was a witness, right? He came to the court on 29/2021 and he stated that against the same Said Faisal, he stated that although he could identify the other two accused, he could not identify this man because he was wearing a cloth, maybe or may not be. Doubtful version he has given. So that case ended in acquittal. Now therefore, the Said Faisal, he wanted to take advantage of the second case and wanted to re-examine or recall him in the first case of 302, in which he has given evidence on 11/8/2014. Friends, here you may be remembering, according to the Evidence Act, whatever statement was given before the court, it can be used as evidence in any other case. You can use it, but here he is being recalled under section 311 of the CRPC. So Said Faisal filed a petition under section 311 CRPC to recall the witness Naushad, but the trial court did not allow. Arey Baba, both of them are different issues. This is a gangsters case, that is a murder case. So, and there is a gap of 7 years also. The first examination was on 11/8/2014. Second examination is on 29/2000. The gap of 7 years is there. So he has not given any contradictory statement. He says that he could identify or not identify. That's all. So please remember, Therefore, the plain in other facts, as far as the other facts are concerned, in the Gangsters Act case, this Said Faisal, he wanted to become an approver. He has asked for the tender of pardon under 306 CRPC. So therefore, definitely he could have been involved in the case. So in such a case, Supreme Court also stated that there is no connection between the two cases, and even though you want to connect them, there is a long gap. So blank gap of 7 years, so he may be able to identify, may not be able to identify, but in no way 311 CRPC is allowed. So reliance is placed by the Supreme Court on the case of Sudevanand versus State through CBI 2012. So please remember, now the Supreme Court did not interfere. So please remember, recalling of a witness can be done only in selective cases but not in all cases. So this is what you have to learn. Please read the judgment and enrich your legal knowledge. Thank you very much.